council parties are still present. There's one evidentiary issue we can discuss now.
There was an indication at sidebar regarding scheduling that they intended to call Heather and Mike McFadden. Heather, as the court may recall, is Mr. McStay's ex-wife and mother to their child Jonah, and Mike is her new husband. The people basically are asking for an offer of proof as to not only what their intended testimony is, because from our recollection of their involvement in this case, there is no relevant information they could give, and counsel has already indicated on the record and to this court that one of the topics they were choosing not to go into. So they were not recipient witnesses to any of the facts relevant in this case. Searches of the house, telephone records, telephone call. I mean, there really is no relevance other than she happens to be the mother of Jonah, and Mr. McFadden now is her husband.
Mr. McGee?
Yes, Your Honor. These are really impeachment witnesses. The people have made this a financial case, that all this involves some financial motive on the part of my client. One of the things that was testified to by Michael McStay was that items were sold and money was given to Jonah, and according to the statements of both McFadden, they never received anything. And so it goes to impeachment of Mr. McStay about where the money went. And so they made their statements clear that the only thing they received was 3 rugs they could throw away, the flooring from the front that they sold, and they got one check for $500 and the surfboard, and that's it.
Don't forget the 2 checks that Dan Kavanaugh wrote in. At least 2.
That's not the testimony of Michael McStay. Michael McStay said he took all the appliances, took all the stuff, sold it, and gave the money for Jonah, but the family never received it.
He did not say all of the money. And he also sued on behalf of Jonah to retain possession of the business on Jonah's behalf.
He being
Mr. McStay, that was his testimony.
Well, if Michael testified he sold various properties, did he say how much he got for it?
Never asked.
he did not say a value.
Okay. Did he say when he sold it?
After they were removed from the house.
After?
He removed them from the house.
After the house was cleaned out, which from various witnesses is probably July of 2010. I don't believe it came out specifically in testimony.
Okay, and Heather and Jonah will say they got a $500 check from whom?
Well, that was one that was written from, and we saw that check with Susan Blake that she wrote to Heather for child support. I believe it was May of 2010. That's
Okay.
the only check that we see that was written, but we wouldn't call Jonah. We'd either call Heather or Michael, either the mother or the father. We wouldn't call both. We'd call one or the other, whichever one's good.
But they're also aware, not disclosing to the court, that Dan Kavanaugh wrote at least two transactions out of the PayPal account, transferring money to Heather on behalf of Jonah for Jonah's child support. And that PayPal account would be the property of Joseph McStay.
Seems to be getting rather far afield, Your Honor. That's the relevance.
So it would be to impeach Michael's statement that he sold the appliances and gave the money to Jonah. So are you suggesting that's a motive why Michael would have killed the family?
That's not my suggestion at all.
Doesn't sound very real. I mean, I realize it is potentially impeachment. If he says, I sold certain items and I gave the money, he says he gave it directly to Jonah.
He says he gave it to Jonah. He didn't say directly to Jonah, but I interpret it as to the McFadden family.
Well, then that's a foundational issue. You can't impeach something that you don't know the foundation for.
Sure I can. It wasn't my witness.
I mean, let's assume that that's true, that he says, I sold these appliances and I gave the money to Jonah. And Jonah and Heather and Mike McFadden say, didn't get anything from Michael.
Michael McFadden was directly asked by Detective Steers if he received any money from Michael McStay or Susan Blake, and he said, no, I don't remember receiving any money or anything that was sold from that house from them. He was asked on point on that issue. He said nothing.
I mean, potentially it's impeachment. If it's a definite, I sold it and gave it to him, and it's a definite, we definitely didn't get anything. If it's, I don't remember getting anything, then it's not really impeachment. And it's really on a collateral matter that doesn't have any real significance. So I would sustain the objection on both relevancy grounds and evidence code 352. Any other issues we can address now, or I need to look at the transcripts? If you can let me know what portions of the 8-hour interview of Mr. Merritt that you want to go into, I can, by page numbers or whatever, I can start reviewing that.
Would it be agreeable with the court, Ms. Moline and I, to meet on that and get that information to the court and to the district attorney by first thing in the morning tomorrow? Since the court is not off tomorrow, at least you can gives us time to go through it all.
Sure,
the court
that's
for a
fine.
day.
Yes, I will be here tomorrow.
Okay.
Okay, yeah, that's fine. Then I can start going through that. And then maybe we can address that. I'm not here Thursday or Friday. Yeah, these aren't here Monday, Tuesday. Could we address that in the morning on the 27th?
The difficulty with that would be I will be at the doctor. So if there's any edits that need to be done before it's presented, well, we can always just call, we can call Boston back another day. So if we want to do it.
I mean, we told the jury to come back at 1:30. I don't want to come in at 1:30 and spend an hour going over the transcript with counsel.
We can address it on the 27th and just not plan to play it on the 27th. We can we'll see.
If Mr. McGee's not here, I can handle that in the morning. So
Okay, that's fine. Then we'll be in session on the morning of the 27th with counsel without the jury to address the evidentiary issues relating to that interview and any other evidentiary issues counsel want to address at that time.
We'll also submit the addition or the edits to the wiretap calls that were referenced in Detective or Sergeant Steers' testimony that were referenced on cross. Because I discussed with counsel about wanting to play those, and he agreed that there's probably stuff that we want to redact out that needs to be redacted, so we have to address those. So we can make those clear and just make sure we're in agreement on those on the morning of 27th as well.
Okay. All right, that's fine. And then I will have had an opportunity to review Mr. Beasley's objection to the personnel records and review those in camera, and we can probably address that as well on that Wednesday.
And there is the motion we received yesterday from the people about moving to deny or exclude Mr. Beasley's testimony in whole on blood pattern analysis. That's something that we'll have to address and file with the court. Maybe we can address that as well on the 26th.
If we can do that on that Wednesday, we can do that. That's fine.
It's my understanding they intend to call him that afternoon.
I'm sorry?
It's my understanding they intend to call him that afternoon.
Yeah.
Receipt of that material, if the court decides to give us any, might not be, it looked like a pretty big packet, might not be the best idea.
Okay.
We would want a couple day or two to review it.
I
Okay.
mean, theoretically, could the court review that this afternoon? Maybe we come back tomorrow morning, get the court's ruling on that.
Sure.
At least that it keeps the ball
Yeah,
moving.
that's fine.
Sure. Yeah, we can do that.
And then, I don't know if the court would then be prepared to address the 352 motion to exclude Beasley at that time tomorrow.
Well, I haven't read it yet, so I don't know.
Mr. Dowdy wrote it, so it's a pretty easy, short read.
Whoa.
Oh, it's direct and to the point. Oh, good.
Exactly.
Well, that'll be a pleasant change.
We might want an opportunity to respond.
Okay.
It's all crazy. We want to exclude our expert, so I think it's without him actually finish his report. They've already said it's not relevant, without even knowing what he's going to say. So, I mean, that's
Just
a
following
little
the lead.
premature.
Just following the lead.
Yeah,
Okay.
I think a lot of
Well,
people-
I'll read the motion and see where we are tomorrow morning and see whether or not it's necessary for you to file a more detailed response or just address it orally. Okay?
Yes.
All right, so we'll be in recess till 9:30 tomorrow morning. We can do that upstairs in Department 21. Does Mr. Merritt want to be here for that? So, Mr. Merritt, you understand tomorrow morning we're going to be discussing these various evidentiary issues. You, of course, have an absolute right to be present for that. Is it your desire to waive your right to be present and agree we can discuss those evidentiary issues with your attorneys and the district attorney present? All of it, of course, will be on the record. That's agreeable with you? Join?
Join.
All right, we'll show a waiver of defendant's personal presence for the in limine evidentiary discussions tomorrow morning.
Just to make sure my P brain is on the schedule. Tomorrow morning at 9:30, and then we're not back until the morning of the 27th.
Right.
Okay, thank you. Unless something changes tomorrow.
Correct.
Okay.
And Your Honor, there are medical records that were received by SDT, medical records for my client. We'd ask that those be released and received.
This is okay. Oh, I thought this was that's the Beasley. All right. There was a subpoena DT issued to San Antonio Regional Hospital for records of Mr. Merritt, and they responded by sending a packet of information with the subpoena DT. I'll release that to defense at this time. Okay? Anything else? Okay? Tomorrow, 9:30.